name's Doug Wotherspoon. This is my presentation of my paper entitled Corporate Accountability, Reappraised and Reinvigorated, presented as part of the conference Questions of Accountability, Prerogatives, Power and Politics. The call for papers for this conference invited submissions that explore the changing nature and the interrelationship between different forms of accountability. The focus of this paper is on corporate accountability since the creation of limited liability companies. And the central argument made is that companies have been accountable to a greater extent than has perhaps been recognized, and that the direction of travel indicates increasing accountability or a requirement for increasing accountability. Although with the benefit of hindsight, it perhaps appears that the Victorian and Edwardian legislation developed in a somewhat haphazard fashion. A coherent legislative framework to hold limited liability companies to account undoubtedly emerged. Indeed, it was clear, even by the mid-1850s, that the phrase limited liability itself served as a red flag to warn the public about what Gower describes as a dangerous new invention. And following on from that, the Companies Act 1862 was a key piece of legislation with a long-lasting influence and effects. Indeed, the Companies Act 1862 can be said to be the progenitor of the Companies Act 2006, not least because the first schedule to the Companies Act 1862 offered standard regulations for the management of a company limited by shares, model articles in the form of Table A, and many of the constituent elements of the 1862 Table A were reproduced in many subsequent legislative iterations of the Companies Act, including the 2006 version and its model articles. The 1862 Act is also, as Tolmie acknowledges, the foundation on which subsequent legislation in relation to company winding up has been based. So overall, part one of this essay argues that the 19th century legislation which led to the creation of limited liability companies in the UK also demanded and promoted accountability on the part of companies and their directors, and that laissez-faire economic and political philosophy, which many argue was a consequence of limited liability, has always been tempered and regulated by directors' accountability and corporate responsibility. According to Schiltz, there was something of a chronological delay faced by judges when considering the meaning of incorporation with limited liability. And amongst the wider public, suspicion of the legislation permitting limited liability was certainly rife. And to a certain extent, Aaron Solomon, who incorporated his bootmaking business in 1892, was caught up in this. And the decisions of the High Court and the Court of Appeal reflect difficulties that the judiciary had in interpreting limited liability and a wider suspicion on the part of the general public with regard to these new beasts. And it's an interesting statistic that between the Companies Act 1862 and the Companies Act 1907, no less than 17 company statutes were passed, with 10 of them being amending acts. But actually, the fact that the legislation was so numerous and prolific actually gives rise to a certain amount of comfort, because during a period in which regulation and accountability had been developing and adapting to meet the needs of a newborn, an accommodation was reached in the early 20th century whereby sufficient checks and balances were deemed to be in place, permitting this new arrival the time and the space to grow and develop legally to serve and meet necessary economic and commercial considerations. Of course, this didn't mean that the torrent of legislation stopped. What it did mean, according to Jeffreys, was the triumph of the company in almost all spheres of economic life. Companies Acts, therefore, continued to appear with great regularity throughout the 20th century. And at the turn of the millennium, although the need for further reform and accountability had been recognised, not least around the subject of duties of directors, the governing legislation remained the Companies Act 1985. As far as part 2 of this paper is concerned, there is a focus on the argument between the proponents of shareholder value and stakeholder value. And these arguments were later typified around the arguments as to the impact and the effect of Section 172 Companies Act 2006, and whether this has had any real impact or influence on the accountability of directors and the actions of companies. However, it's argued that this debate must take place in a wider historical context, dating back virtually to the emergence of limited liability companies. In the UK, there is, of course, the famous case of Hutton and West Cork Railway. And in the United States, the argument between shareholder and stakeholder primacy was arguably ignited in the famous US case of Dodge and Ford Motor Company. This debate never really went away, but the heat reappeared as a result of comments made by the famous economist Milton Friedman in the 1970s. Friedman's views were challenged at the time, and of course subsequently by, amongst others, Freeman in the 1980s and John Elkington in the 1990s. And by the 1990s, CSR was firmly on the agenda for many companies. And the issue of sustainability really appears as a result of the UN's Brundtland Commission of 1987 and its definition of sustainability. Ultimately, directors' duties were codified in the Companies Act 2006, but those who had anticipated a shift towards the stakeholder camp were ultimately left somewhat disappointed, even if the concept of enlightened shareholder value was the result of the Section 172 of the Companies Act 2006. Because that section specifically states that directors must have regard for other constituents beyond the shareholders. And the codification of directors' duties as they now appear in the Companies Act 2006 requires the application of the concept of ESV, even although it seems that the largely subjective judgment of the directors as to what is in the best interests of the company remained paramount. Part 3 of the paper argues that current trends, including not only legislation and case law from other jurisdictions, but also non-statutory guidance and the actions of shareholder activists point inescapably towards companies having to operate in the face of increased environmental, social, and governance regulation and scrutiny, if global issues such as climate change and sustainability are to be addressed. And whilst on the face of things, Section 172 Companies Act looked like a perpetuation of stakeholder theory, the fact that the case of R and people, R on the application of People and Planet and HM Treasury, seemed to offer sustenance for the perpetuation of stakeholder theory. Mr. Justice Sales, in that case, was clear in his comments, which arose from the banking crisis of 2008 and the injection of huge sums of public monies by the Treasury to prop up certain banks, Royal Bank of Scotland amongst them. As a result, the UK government became the majority shareholder in Royal Bank of Scotland, and campaigners from a number of pressure groups commenced action for permission to seek a judicial review of the decision of HM Treasury on behalf of the UK taxpayers to invest public monies to finance companies and projects which apparently undermined the commitment of the UK government to protect human rights under the Human Rights Act 1998, and also the question of emissions of greenhouse gases embodied in the Climate Change Act 2008. However, Mr. Justice Sales gave short shrift to the pressure group's arguments. He maintained that decisions regarding the management of RBS will be matters for the judgment of the directors of RBS. And although that seems to be clear, and that seems to be the position within the UK, as we shall see, other courts in other countries have taken a somewhat different view. Now, the subject of ESG has been mentioned. ESG stands for Environmental, Social and Governance. And Polman argues that the debate in the 21st century has shifted from looking beyond merely making a business case for CSR based on altruistic and ethical justifications, essentially a voluntary compliance with CSR principles, to a focus on ESG matters underpinned by legal governance. And as a result of that, there are a number of current trends which point towards increasing regulation on various levels against companies. First of all, there have been a number of legal cases against national governments and individual companies succeeding, using legal principles, existing legal principles, as the basis for their decisions. Roger Cox is a lawyer and is the author of a book called Revolution Justified: Why Only the Law Can Save Us Now. And the central tenet of his argument is that the judiciary provide a democratic option for climate justice. In 2015, his book inspired the Urgenda Foundation to take the government of the Netherlands to court for its lack of urgency on the subject of climate change. The Dutch government lost the case and promptly appealed to the Court of Appeal at The Hague, but the initial decision requiring a 25% reduction in carbon emissions was upheld, leading the Dutch government to appeal to the Supreme Court of the Netherlands. In 2019, in a landmark decision, the Supreme Court of the Netherlands affirmed that since the government was responsible for both human rights and the management of carbon dioxide emissions by the country as a whole, the 25% reduction in carbon emissions ordered initially must stand. Earlier this year, in May, Cox followed up that success on behalf of Milieu Défensie, Friends of the Earth in the Netherlands, in a case brought against Royal Dutch Shell in the District Court of The Hague, requiring the company to act to cut its carbon emissions faster. The action brought on behalf of Milieu Défensie succeeded, and the decision has generated huge international interest and is currently subject to appeal. These two cases offer more than a suggestion that the law can be used against national governments and individual companies to hold them to account. Beyond that, shareholder activists are now using their legal powers to raise matters of concern and to hold companies to account at company AGMs. Under the Companies Act 2006, traded companies have always had certain obligations. When faced with a request by 5% of the shareholders or support from at least 100 members holding an average sum per member of at least £100, matters may be added to the agenda at AGMs. And already this year, we have seen significant concessions from major UK PLCs such as Tesco and HSBC. In the case of Tesco, the issue was the increased provision of healthy food in its stores. And in the case of HSBC, the issue was the defunding of the coal industry. In both instances, the resolutions were coordinated by Share Action, whose web pages record these and other concessions made by a number of household names in the UK and in the EU in response to coordinated shareholder resolutions. Finally, there is the impact of non-statutory codes and principles, so-called soft law. And it seems that there is a continuing trend, a current trend and a continuing trend for these to have an impact on listed companies. Whilst by very definition, they don't have the force of law, this apparent weakness is, it is argued, almost a strength. Because the soft law embodied, for example, in well-established principles such as comply or explain, as embodied in the UK Corporate Governance Code, has been replicated in other corporate spheres. In the UK, peer pressure engendered by recent reviews conducted by Hampton Alexander and Parker has ensured that significant steps have been taken by listed companies to achieve female representation, greater female representation on boards, and to ensure that boards also become more ethnically diverse. The argument, therefore, is that a combination of traditional legal methods, legislation, case law, and more unconventional activities on the part of shareholder activists, nonetheless using the law, and soft law methods and reports and reviews are giving rise to greater success in holding companies to account and also in terms of strengthening corporate accountability. Thank you for listening to my presentation. My contact details are as follows: d.wotherspoon@worc.ac.uk. Thank you.